Today on Legalese, we are discussing the exciting opinion in one of the most anticipated cases for the Supreme Court term, SEC v. Jarkesy. Now, this case is an epic win for every American's right to a trial by jury, and it has major implications for the Fifth and Seventh Amendment that all come out in favor of liberty. So stick around because you are definitely going to want to get the full breakdown of this case coming up right now. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, let me just remind you guys real quick, if you want to find out more about our show, you can go check out our homepage over at legalespodcast.com. And if you want to stay up to date whenever I put out new content, because I don't just put out videos on YouTube, I post to alternative platforms. I write articles on Substack. I do show notes pages. And if you want to get notifications for some or all of those things, either way, all you have to do is go head over to legaleshow.com where you can subscribe to our newsletter. Let me know what kind of content you want to get notifications about, and those will be sent right to you. All right, we have a lot to get to today, and I am genuinely excited to get to it. So let's jump on in here. So today, the Supreme Court dropped two massive bombshell cases that are absolutely the most important cases for this term. Now, yesterday, when I was making my Murphy v. Missouri video, I said that the most important case of this term so far had been Murphy. Now, at that time, I had not had a chance to read Jarkesy and Loper Bright yet, and so I stand corrected. It would truly be hard to overstate just how big of a deal these two cases really are. Not just for the merits of their respective cases, but also for the court's decision in these cases. However, these aren't just two bombshell landmark decisions that are important cases in this term. They are, in fact, and I realize this may sound hyperbolic, but I truly mean it, possibly two of the most important Supreme Court cases they have ever issued. Why? Well, while every case I cover here on the show is a case that has huge implications for constitutional law, these two had stuck out to me the entire time as true landmarks. And this is a big deal because the proliferation of administrative law has become a much greater danger to our individual liberties than cases involving more fundamental civil liberties, such as cases that are dealing with facial challenges to the First or Second Amendment. So let's dive on in to an in-depth examination of the court's decision in Securities and Exchange Commission v. Jarkesy. So at its heart, Jarkesy is a case that challenges the dual court system that has been created by administrative law. When administrative agencies want to enforce an act of Congress, they can bring an enforcement action in one of two forums. They can file a suit in federal court, or they can adjudicate the matter themselves. Now, the forum in which the agency selects will dictate the procedural protections enjoyed by the defendant and the remedies available to the SEC. So, when a case is heard before a federal court, a jury acts as the finder of fact, and an Article 3 judge will preside over the case. Additionally, the federal rules of evidence and the ordinary rules of discovery will govern the litigation. But when an administrative agency adjudicates a matter internally, there is no jury. The SEC presides over the case. The agency's internal division of enforcement is the prosecutor in the case, and the agency's own administrative law judge is responsible for finding facts, deciding discovery disputes, and it is the SEC's own internal rules of practice which govern the proceeding. So, in the case we are talking about here today, a case that was brought against George Jarkesy for securities fraud, the SEC had opted to adjudicate the matter in-house. Now, in that case, the final order would determine that Jarkesy and his company, Patriot 28, had committed securities violations and they were levied a civil penalty of $300,000. And so George Jarkesy and his company would petition an Article 3 court for judicial review. And so the Fifth Circuit would vacate the order on the grounds that adjudicating the matter in house violated the defendant's Seventh Amendment right to a jury trial. And this case would go on to the Supreme Court, where we would get a 6-3 decision, with 6 judges affirming the decision of the Fifth Circuit and 3 more rejecting it. And they would end up affirming the Fifth Circuit's basic holding that the petitioner's case violated their Seventh Amendment right to a jury trial. Now, the majority opinion in this case would be authored by Chief Justice John Roberts. It was a really excellently written opinion, too, and it would be joined in full by Justices Thomas, Gorsuch, Barrett, Alito, and Kavanaugh. And in the majority opinion, they would hold when the SEC seeks civil penalties against a defendant for securities fraud, the Seventh Amendment entitles that defendant to a jury trial. Now, the chief will go on to say that the question presented in this case, whether the Seventh Amendment entitles a defendant to a jury trial when the SEC seeks civil penalties for securities fraud, is straightforward. Now, Chief Justice Roberts' opinion is an examination of originalist, textualist, and doctrinal sources of law. And following the precedent set forth in the Grand Financiera and Tull cases, this action would implicate the Seventh Amendment because the SEC's anti-fraud provisions replicate common law fraud.
You got me now. You got me now. You got me now. Oh, you figured me out. You fucking income fucking poop. You figured me out. You got me red-handed. You got me red-handed.
And additionally, the public rights exception to Article 3 jurisdiction does not apply here because the present action does not fall within any of the distinctive areas involving governmental prerogatives where the court has concluded that a matter may be resolved outside of an Article 3 court and without a jury. Now, the chief would go on to explain why this action implicates the Seventh Amendment. The right to a trial by jury is of such importance and occupies so firm a place in our history and jurisprudence that any seeming curtailment of the right has always been and should be scrutinized with the utmost care. When the British attempted to evade American juries by siphoning adjudications to a juryless admiralty, vice admiralty, or chancery court, the Americans would protest and they would eventually cite this practice as one of the justifications for declaring independence. Furthermore, in the revolution's aftermath, concerns about the proposed constitution lacking a provision guaranteeing a jury trial right in civil cases was, this was according to Federalist number 83, the most successful critique leveled against the document during the ratification debates. And to fix that flaw, the framers would promptly adopt the Seventh Amendment. Ever since, every encroachment upon the jury trial right has been watched with great jealousy. And the Seventh Amendment guarantees that, in suits at common law, the right of a trial by jury shall be preserved. Now, the first question in this case is whether the claim that the SEC brought against the hedge fund founder and investment advisor George Jarkesy, seeking penalties for misleading statements he made to investors, is a suit at common law to which the Seventh Amendment would apply. After all, like most administrative claims, it rests on a federal statute, not the common law, and it requires the agency to establish facts that do not match a cause of action known to the common law in 1791 when the states ratified the Seventh Amendment. However, Roberts would go on to explain that the right is not limited to the common law forms of action recognized. But when the Seventh Amendment was ratified, It would extend to any statutory claim if the claim itself was legal in nature. And of these factors, the chief would say, the remedy is the most important, and in this case, the remedy is all but dispositive. Now, in much of the opinion, Chief Justice Roberts makes an overwhelmingly powerful argument that the SEC fraud cases are, in the words of the Seventh Amendment, indeed suits at common law, which can only be tried by a jury and not a suit in equity or admiralty.
Just one moment. Mr. Gribble, remove your hat in my courtroom.
I do not recognize the authority of a court that hangs the gold-fringed flag. A flag with gilded edges is the flag of an admiralty court. An admiralty court signifies a naval court-martial. I cannot be court-martialed twice. That is all. Furthermore...
Bailiff, gag him. This must be a tight...
where the right to a jury trial has not historically been available. Now, on the other side of this was Justices Sonia Sotomayor, who would write the dissenting opinion, which would be joined by Justices Elena Kagan and Ketanji Brown Jackson. And reading from the bench, Sotomayor would call the majority's decision a devastating blow to the manner in which our government functions. Though it's worth noting that they really did not have any issue with the court's analysis of whether Jarkesy's suit is a suit at common law, to which the Seventh Amendment would apply. Now, in turn, the chief would go on to elaborate that because the SEC is seeking civil penalties in the form of monetary relief, and because money damages are the prototypical common law remedy, in particular, he explained that for only courts of law issued monetary penalties to punish culpable individuals, which means that civil penalties are a type of remedy at common law that could only be enforced in a court of law. Now, most importantly here, because the SEC is not obligated to return any money to victims, its civil penalties by definition are designed to punish and deter and not to compensate, and that effectively decides that a defendant would be entitled to a jury on these claims. So, when it comes to where exactly did the justices divide on this case, that would come in the second step, which would analyze the public rights doctrine. So, what exactly is the public and private rights distinction that would split the court? The Supreme Court has held that Article I courts can adjudicate cases involving public rights. These are cases that arise between a private actor and the government, and the public rights theory can be traced back to the court's 1855 ruling in Murray's Lessee v. Hoboken Land and Improvement Company. And in that case, Justice Joseph Story would explain that although Congress cannot withdraw from federal courts the jurisdiction to hear suits at common law, equity, or admiralty, there are matters involving public rights which may be presented in such form that the judicial power is capable of acting on them, and which are susceptible of judicial determination, but which Congress may or may not bring within the cognizance of the courts of the United States as it may deem proper. So, in essence, the court distinguished between matters that historically had been decided by courts and matters that arose between the government and others that had been historically resolved by executive or legislative acts. Now, the public rights exception to the Seventh Amendment recognizes and has recognized for centuries that when Congress creates a public right, it can freely assign the matter for decision to an agency without a jury consistent with the Seventh Amendment. And the controversial question in this case is how to decide whether the SEC's claim for civil penalties involves a public right. Now, in writing for the majority, everything about the doctrine, according to Chief Justice Roberts, depends on the nature of the SEC's claim for relief. Because the hallmark of public rights is whether it is made of the stuff of the traditional actions at common law tried by the courts at Westminster in 1789, And if that is so, then the matter presumptively concerns private rights and adjudication by an Article 3 court is mandatory. Now, when Roberts turned to explaining why this particular matter does not involve a public right, he would rely heavily on the Grand Financiera precedent in 1989, which was a decision that held that the public rights exception did not protect a claim in a bankruptcy proceeding to recover a fraudulent conveyance. Now, for Roberts, the statutory action for fraudulent conveyance were so similar to the statutory action here that it effectively decides this case. And again, writing for the majority, he would say, what matters is the substance of the action, not where Congress has assigned it. Thus, it cannot matter that Congress put the right in a novel regulatory regime, lest the court permit Congress to siphon this action away from an Article 3 court. Because the fraud claim in Grand Financiera was also statutory, the same result should apply here. Now, in Justice Sotomayor's lengthy dissent, she proceeds from an entirely different conception of the public rights doctrine. For her, the key point was that the right in question is one that Congress gave to the government. So she says today, for the very first time, this court holds that Congress violated the Constitution by authorizing a federal agency to adjudicate a statutory right that inheres in the government in its sovereign capacity. So, for Justice Sotomayor, cases where the government itself is the claimant were the easy cases. To her, that is the very definition of public rights. Justice Neil Gorsuch, joined by Justice Clarence Thomas, would file a substantial concurrence in this case, and he would say that collectively the Seventh Amendment, Article 3, and the Due Process Clause should require a jury trial and conventional civil litigation before the government can deprive a citizen of money. And doctrinally, they seem to reach the question the majority avoided, which is suggesting that the public rights exception applies only to the collections of revenue, customs enforcement, immigration, and the grant of public benefits. And in his powerful and persuasive concurrence, Justice Gorsuch would emphasize that Jarkesy's case's implications of Article 3's promise of a life tenured judge to hear suits at common law, as well as implicating the Seventh Amendment, were at stake here. Justice Gorsuch also observed that the Fifth Amendment's due process clause was implicated as well because the SEC was arguing that it could violate the separation of powers by combining legislative, executive, and judicial power all in one administrative agency. Now, the majority opinion is likely to have an immediate and notable effect on the federal administrative state. Justice Sotomayor would discuss 24 agencies that impose civil penalties in administrative proceedings, and few, if any, of them fall within the categories that the majority validates. Now, among the most prominent that I could mention real quick offhand are the FDA, the EPA, the FCC, and the CFPB. Now, I doubt if any of those agencies will be able to enforce civil penalties reliably in the immediate future. And this hit will be especially hard for agencies that depend on revenues from penalties to support their budgets, as Congress seems little minded in recent years to offer agencies new funding. However, really, the most surprising thing about this decision for me is the consensus that Roberts was able to build for his majority. Now, in previous cases, in these exact same areas of law in the last few decades, they have always involved fractured and splintered plurality opinions with multiple partial concurrences. However, Roberts wrote for 6 of the 9 justices and had all 6 joining every single word of his opinion. The concurrence by Gorsuch, joined by Thomas, was merely additional points that he wished to make on top of Roberts' opinion, which he completely agrees with. Now, this is huge because this signals in a very powerful way that the blow that Jarkesy strikes at the administrative state is not temporary or lightly considered, and not something from which litigants should hope for relief or ameliorative clarification anytime in the foreseeable future. And overall, SEC v. Jarkesy is, in my opinion, a correct and incredibly persuasive six justice majority opinion, which holds that in civil fraud suits, at least, the SEC must bring its cases before an Article 3 judge and afford the defendant, who it is prosecuting, all the rights of a civil jury trial. It cannot prosecute such a suit before its own internal administrative law judges. In this way, Jarkesy is an important victory for both the rule of law and for downright common fucking sense. Now, that's all I have for you guys here with this video. However, you are going to want to stay tuned because I have one more video coming out today, and I have absolutely saved the very, very best for last. We are going to be talking about the bombshell decision in Loper Bright Enterprises versus Raimondo, and how that decision straight up murderized Chevron deference. You're not going to want to miss it. So, subscribe to the channel, and while you're at it, if you would do those other things that help to trigger Algorithm rhythm, I would appreciate it. If you like this video, hit that little like button down there. If you disliked it, you're free to hit the dislike button. Leave me a comment. Let me know what you thought about this video, or about the topic we discussed, or really whatever on your mind. So until next time, this has been Bob for Legalese, talking about SEC v. Jarkesy, and of course, as always, Cartago de lenda est.